Thank you very much for being here, and we will now continue with session 4. We try to catch up with the time that we lost. And it is a pleasure for me to moderate this panel on good practices and lessons learned for improving the quality and effectiveness of legal aid. You may know that this session has been selected as one of the 2 most popular ones in a survey of the participants of this conference. And that is in line with one of the main findings of the UNDP and UNODC Global Study on Legal Aid that we launched at the last conference in Argentina in 2016, where member states and national experts named this topic as their most pressing concern. And among other things, the study encourages the global sharing of experiences, lessons learned, and good practices, which is what we are doing here today, and which we will continue tomorrow in session 11A. Experts in the study assessed that people's lack of confidence in the quality of legal aid services was one of the 3 most significant challenges faced by the poor and vulnerable in accessing legal aid services globally. The normative guiding framework on delivering effective, sustainable, accessible, credible, and quality legal aid at all stages already exists. International instruments we heard about this morning, so I'm not repeating them all, but among them are the ICCPR, the Declaration of Human Rights, and the UN principles and guidelines that form the basis for our conference here today. All these focus on the knowledge and skills of individual providers, which include the education and experience to address the gravity of offenses dealt with, and also the rights and needs of women, children, and other groups with specific needs, which speakers in this session will address. The principles and guidelines also establish that states should adopt national standards based on their systems to ensure quality of legal aid services and adopt codes of conduct for providers, whether they are lawyers or paralegals. A number of regional instruments also include the right to fair trial and provisions on access to legal aid as a key measure, which were interpreted over the years to imply effective defense and, so to say, active action by lawyers to protect the interests of their clients. We encourage all states to implement these global and regional instruments in a holistic way. As stated by the General Assembly when it adopted the principles and guidelines, implementation should be done while bearing in mind the diversity of criminal justice systems among different countries and regions around the world, and the fact that legal aid is developed in accordance with the overall balance of the criminal justice system, as well as the circumstances of countries and regions. So the approach to quality assurance in any given legal system will depend on how legal aid is organized and the actors that are involved in its delivery. It will depend upon, for example, whether there's a legal aid body responsible for administering legal aid, and whether there is a contracting relationship between that legal aid body and the legal aid service providers, or whether legal aid is provided through a public defender service or mainly through private practitioners. Taking into account the reality that countries implement standards differently, UNODC, with the input and support of many of you here today, and many more that couldn't make it to Tbilisi, is currently developing guidance in the form of a handbook on quality of services, in which we highlight how countries frame, establish, and evaluate quality to achieve more fairness and effectiveness in their criminal justice systems. We will talk more about this tomorrow, which is a direct form of assistance to cater to the growing need for practical guidance and tools, including experience sharing among states, practitioners, and researchers on what works and what doesn't work everywhere. To ensure efficient use of both financial and human resources, and to ensure equal access of beneficiaries, monitoring and measuring the quality of services provided is crucial. From the broader perspective of the legal aid system, a long-term strategy guiding the evolution and sustainability of quality legal aid should be developed in each country in consultation with all the relevant stakeholders. Against this background, it is my pleasure to introduce the first of our panelists, who really doesn't need any introduction, but I'm still going to say it, the Honorable Dunstan Mlambo, Judge President, the Gauteng Division of the High Court and Chair of the Board of Directors for Legal Aid South Africa, who will share with us his views on quality legal aid services.
Thank you very much, Anika. And I greeted you all in the morning. I'll do the same thing, but I also want to greet my fellow panelists here. My task now is to talk for 2 minutes because I'm told I had a lot of airtime in the morning. The other panelists will decide how they take the rest of my speaking time. But my task this afternoon is to try and understand the thinking globally about this phrase, quality legal services, quality legal aid services. In the global study that Anika referred to, she mentioned that the biggest concern raised regarding legal aid services was the quality thereof, that it was affecting the confidence of people towards accessing that. We know that in the UN principles and guidelines, throughout, the theme of that document is that the legal aid services must be of a high quality, must be effective. We know that in our regional instruments, emphasis is placed that access to legal aid must be access to quality legal aid services. So my purpose today is to say to you, do we understand what we're talking about? Globally, that is, when we talk about quality. And I want to see if I could leave the room having established that we do have consensus. One thing I'm sure of is I know there is consensus in the room here that access to legal services must be access to quality legal services. I know there's consensus in that regard, right? So I think for me, that's a very good start. Now, in my own take, by effective, when we say access to effective legal services, we mean access to high quality legal services. So what do we mean when we talk of high quality services? Do we have the same understanding in this room from our different legal systems? I come from an adversarial legal system where I can cross-examine a witness to the ground. Some of you come from inquisitorial legal systems where there are certain checks and balances in terms of how far you can go, whether you can do investigations or you can interview witnesses, right? But the purpose of talking today is to see if one can encourage thinking about the meaning of quality across the board, right? And I want to do that by just taking 2 minutes to talk about my own experience about what we mean by quality in South Africa. We have a quality management program that's institutionalized in Legal Aid South Africa. It aims to ensure that there is one uniform quality standard in the entire organization that every lawyer who delivers legal services to clients must achieve. Every aspect of the services that are delivered by us, legal services, is subject to review. This encompasses chamber work, what you do in your chambers, in your office, court work, what you do on your feet in court, legal advice, what notes you take, what statements you take, as well as telephonic legal advice. We've got a toll-free legal advice line in South Africa. So we review the legal advice given over that telephone line. So all our lawyers are subjected to a quality assessment or quality audit at predetermined regular intervals. And this includes all our paralegals, our trainee lawyers, as well as our quality lawyers. The quality target that we want to achieve is determined, taking into account the type of work, as well as the experience level of practitioners performing our work. What we prioritize is the transparency and consistency in the quality review process of the quality assessments that we conduct. We have built in self-reviews, the practitioner reviews himself or herself, peer reviews, you are reviewed by your peers, supervisor reviews by those who supervise you, as well as the regional supervisory teams that look at the work. So all this is done through an independent legal quality assurance unit that is staffed by senior lawyers who've been practicing law for a very long time. So we also deepen this review in terms of, as I said, going to look at the advice that you gave to your client. We go in there and check because you kept your notes. We also check what you've done when you've appeared in court. We send lawyers without you knowing that there'll be lawyers in your court. We call it court observation reviews, where the senior lawyer checks whether you're covering all the bases. And we do it deliberately, that we are not told that he'll be there. And we've had instances where our senior lawyers who've realized that our lawyers who are handling a case are in trouble, and they're in trouble because of inexperience, they'll simply stand up and ask the proceedings to be stopped, and they go introduce themselves to the court and take over the proceedings and run and finalize it, or even coach our lawyer. But that's the benefit of our quality interventions as Legal Aid South Africa. Now, what that tells me is there is a need. We're all human beings. We do make mistakes. But in South Africa, we've realized that, we've institutionalized that, and our quality interventions have ensured that we regain a lot of credibility in the people that want to use our services. Now, I come back to what I thought I'll talk to you about. I've just shared with you what the South African experience is in terms of tracking quality. In 2016, the ILAC titled a publication called Measuring Justice. It was a bold attempt at defining and evaluating quality for criminal legal aid providers. You've seen that document, you've read it. In that document, the ILAC asked and answered 3 questions. 1, why does quality matter? And I think there's consensus in the room that why does quality matter? The second question is, what is quality? And the third question is, how do we measure quality? The meaning of quality, according to the ILAC, is that we can clearly define quality legal representation with reference to a set of consensus international norms. I've mentioned them. That together tell us that what legal aid providers need to do in order to ensure fairness and maximize justice and liberty for their clients. Now, I'm told that I don't have any more time, but the ILAC has done further in-depth research on this topic. And they've produced a document where they've actually tracked the quality interventions of some 20 countries. What do you do pretrially? Do you simply know, as a legal aid provider, you have a client in that jail and you simply go and meet that client in court without having consulted? You know? So that document tracks what these 20 countries do, and it has come with 10 principles, according to the ILAC. 10 quality interventions that would ensure that the services you provide are of high quality. These principles detail what happens at the pre-trial stage, the pre-trial litigation such as bring bail application, adequate preparation in terms of early consultation, thorough consultation and statement taking, fact gathering, background investigations, as well as interviews with witnesses. During the trial, how do you prepare your client for trial? What case research do you go through? How do you conduct your cross-examination, as well as post-trial in terms of lodging appeals? Now, I think it's a worthwhile document to look at and apply our minds to. But all it does is it recognizes that there's a diverse nature of interventions across the board. But what comes out is that there is a beneficial aspect to this thing, in the sense that we all are doing quality interventions in our respective corners because we realize the importance of quality. But isn't there a case to be made that we need to start thinking about coming up with a global or international instrument that tracks quality? Either you could call it a guidance tools or norms and standards or a model code or international principles of quality legal aid services. Now, I'm told I'm over time, but I'm just saying, I want to leave you with that. Think about it. I think from where I sit, there is a good case to be made that let's start thinking, like we did with the UN principles and guidelines, let's start thinking of coming with a document that comes up with norms and standards or principles about quality legal aid services. Thank you very much.
Thank you, and I'm sorry. I'm very sorry, I have to cut off people, but we try to make up for this in Q&A, so think about what you would like to grill Judge Mlambo with later. Thank you for mentioning this. As we saw with the global study, data is extremely important, so we are looking forward to also hearing more about the research that is done by the ILF. And now let me move on directly to Mr. Jago Russell, the Chief Executive of Fair Trials, who will touch upon an issue that Judge Mlambo has also already mentioned, the impossibility of a fair trial without quality legal aid service. So without further ado, I think your presentation is put up. The floor is yours.
So really, I mean, I entirely agree with what almost everything that Judge Mlambo ever says, I imagine. I think it's absolutely crucial to be building a consensus around the understanding of quality legal aid. And I really want to outline how I think we could approach this question. And I think the starting point is by being really clear about what legal aid services are for. I think they're for getting from A to B. I think A is the beginning of the criminal process. And if you look at that from the perspective of the accused person, it's a terrifying experience. You know, you've got the overwhelming power of the state. You've possibly been arrested by the police. You're surrounded by legal jargon. That's where the criminal process starts for a defendant. And at the end of the criminal process, this is where you want to end up. You want to end up with people that are guilty of crimes where that's been proven beyond reasonable doubt to be convicted of those crimes. This is a picture of Anders Breivik, convicted in Norway of the horrendous shootings. You also want acquittals. You often want to get cases diverted out of the criminal justice system altogether if they shouldn't be there. You want state power, the power of police and prosecutors, to be accountable to the law. And you want the public to trust in justice. So this is what quality legal aid services are for. They're for getting us from A to B through a fair criminal justice system. As already has been alluded to, one of the challenges I think in building consensus around quality is the fact that criminal justice systems differ. There are lots of different types of criminal justice systems. A lot of the work of Fair Trials has focused on the European Union, kind of one of the most legally diverse regions of the world. But I think we can find a solid basis on which to build this understanding of what quality looks like in terms of legal aid services. And I think we have to build it from a point of consensus. And the point of consensus is the fact that everybody has the right to a fair trial. And underneath this basic underlying concept, there are numerous enumerated principles and norms that are applied in different ways in different types of legal system, but that every legal system should comply with. I think we need to build our understanding of what quality legal aid systems look like, what quality means in this context, from the bottom up. We start with these international fair trial rights, these things that there is global consensus on already. We then need to ask the second question, so what role do legal aid services play in ensuring the protection of those rights, those constituent parts of a fair trial? And then from that, I think we need to build really robust performance standards. You know, how do you translate the role that legal aid services need to play in order to ensure a fair legal process into something that you can measure? You need to build performance standards. I'm going to give you 3 very brief illustrations, if I have time, of how you might do that. So let me start with the anathema of a fair legal process. Familiar in many jurisdictions around the world, criminal convictions based on confessions coerced or tortured out of suspects. So, again, clear global consensus that you should not be relying on torture evidence in any criminal proceedings. But the reality is that it's a norm. It's what happens across. It's normal practice in many jurisdictions in the world to build criminal cases on torture evidence. So I think we could use that as a starting point for defining what performance standards might look like for quality legal aid services. Couple of suggestions. I think one thing here is independence. We've talked a lot about independence. It's absolutely crucial. It's crucial that the defense lawyer isn't part of the system that's involved in torturing confessions out of defendants. They need to be independent advocates for the rights of the defendant. Confidential communication. Again, this is absolutely crucial. The ability to speak, legal aid services need to involve people speaking to accused people before their first interrogation, so they can ask, they can find out whether there has been torture or mistreatment. Attending the police interview. Until recently, many countries in the European Union didn't allow lawyers to attend police interview, the point at which coercion is often so, forcefully applied to defendants to get them to confess, and challenging unlawful evidence. One thing we ought to be ensuring is that in every legal system, whatever the type of legal system, that legal aid service providers are challenging evidence that's being used as the basis for a conviction. Second example, fighting the overuse of pretrial detention. Pretrial detention should be an exceptional measure only to be used as necessary as a measure of last resort in limited circumstances. So, again, there's global consensus on this basic idea. But, you can't see the numbers, but basically that map is showing you that the world's in a mess when it comes to pretrial detention. Many countries around the world are detaining far more people pretrial than they should. So, what kind of performance standards could we develop to ensure that quality legal aid services are tackling, preventing the unjustified use of pretrial detention? I think, again, you start with the idea, prevent unnecessary and arbitrary pretrial detention, and you come up with a few really concrete things that effective quality legal aid service should be doing. Advocating for pretrial release quickly, and I think also repeatedly, not accepting the first decision to detain somebody, but challenging it. Gathering evidence to support release. We did a big study in Europe on the decision-making in pretrial detention cases, and one of the things we discovered was that one of the causes of the overuse of pretrial detention in the European Union is the fact that lawyers simply were just not doing their jobs. Lots and lots of lawyers, lots of people were appearing before court where their liberty was to be determined, and the lawyer wasn't even there. It was very rare for us to see cases where lawyers were in fact actually gathering any evidence to demonstrate that it would be appropriate for their client to be released, that they had a job or a stable kind of housing or financial situation. These things were just not being gathered, and also challenging the case for detention from the prosecution, not just accepting that and taking it for granted. I'm still okay, so I'll go on to the third one. So this is often not talked about, and there are lots of different things I could be talking about, but effective participation, I think, is a really important one. Really familiar in the context of juvenile justice to use this phrase, and we've heard some about that today. I think it's crucial, and I think, again, it should be a key feature of what quality legal aid services look like. The right to information, to be heard, to be empowered to make key decisions in the case that affects your freedom. The reality is very different. This is from a few images from an animation that Fair Trials launched a couple of years ago, which basically shows a person, a kind of little person made out of plasticine, kind of being dragged through this justice system at a rate of knots incredibly quickly with no idea of what was going on around them. A kind of judge sitting up there, shouting at them, no understanding of what was happening to them. Again, I think we need to define quality standards for legal aid services which ensure that actually there is effective participation. So again, confidential communication, counselling the client, I think is absolutely crucial. And I'd love to see quality standards which assessed whether or not lawyers moved beyond legal jargon to speak in the kind of language, to counsel their clients in the kind of language which means that they'd actually understand what's going on, that they understand the significance of their decisions. Judge Mlambo also already referred to this fabulous publication by ILF on quality legal aid services. In fact, he read this quotation out, so I won't repeat it, but anyone that's interested in this should look at that document. So my guide for this process, which is absolutely crucial on building consensus around the understanding of quality, is start from the question, what are legal aid services for? The answer, fair criminal justice. How do we define quality? Well, I think we define quality by defining what legal aid services need to do in order to achieve a fair criminal justice system. And I think these international fair trial standards provide the basis of consensus, of standards on which to build an understanding of quality. Thank you.
Thank you very much, Jago, and also for being perfectly on time. This raised some important points that I think indeed we all agree is a crucial part of legal aid service delivery with high quality. And now, without further ado, I would like to hand over to Professor Avrom Sherr, who many of you will know, the father of peer review, Professor Emeritus of the Institute of Advanced Legal Studies, who will talk about another very important point, quality and funding, proving value for money. Please, the floor is yours.
Thank you. I may need to wait for the PowerPoint to come up since I cannot actually speak without a PowerPoint. When I come home in the evening and my wife says, "What sort of day did you have?" I say, "Hold on, I've got a little PowerPoint to show you, which explains the day," since I'm completely unable to talk without it. So what am I going to concentrate on? It's going to be a little bit different from what the other people have talked about. It's going to be, if it ever comes up, it's going to be about how to do it. So I think the others have in general spoken about what to do, but I'm going to talk about how. And I'm going to show you the research that enabled us to say how and how it would work in a moment. Any moment now. We have at least 4 people. So this is an essence of quality. The judge spoke about the possibility of actually being in court and watching court presentation. I thought that was something that was really interesting, that we'd not heard almost anywhere else previously. In England, the bar had decided that they would have a system for judging the quality of counsel in front of the courts, but no one could agree who would be good at doing it. There was a suggestion that the judges should be the people who did it. However, it was pointed out the judges have a conflict of interest in relation to participants in the system, and they might prefer someone who was nice and easy rather than someone who held them to a position which they may not want to be in. So we decided no judges. We also tried out a system where we could actually send people to court, but we found that the people we were reviewing were never in court at that time because systems of justice tend to change. So whatever you organize isn't actually going to happen at the time that you work it out. So we decided instead of going to court, instead of watching the way in which lawyers actually interview their clients, instead of managing the system of negotiation with prosecution by watching, we decided we would look at the file in which the lawyer had written down what it was that they'd done, the process document of all of the cases in which they have been involved. And that was what we have concentrated on in terms of reviewing our lawyers. Wonderful. So if I continue, I think this is an obvious question, but let's look at it. You can't just ask the client because the client actually really doesn't know, unless they have been in court a number of times and for the same thing, and they've had a number of different lawyers. They don't know. There is dissonance, knowledge dissonance between them. And because it's a free service, they do not complain. Clients do not complain in legal aid. They're vulnerable. They're in crisis. And if you've ever seen the book by Bloomberg, Practice of Law is a Confidence Game, unfortunately it shows in the United States, but some years ago, before the ILF started, it said it was very easy for lawyers to play the system, to pretend to the clients that they were actually doing something without doing anything. So I'm looking at ensuring value for government, for the taxpayer, in terms of all of this. And this is the research that we did, covered 142,000 cases, 82,000 were completed. We looked at 100 different lawyer firms, 43 not-for-profit. It was a randomized controlled trial. It was, in terms of research, what was called the gold standard. So we looked at 4 different methods for charging for work. And we looked at 4 different methods of reviewing work: briefcase was looking at all the outcomes. It looked at the numbers. Peer review looked at the cases. We had model clients, and we also had client survey. In relation to the peer review element, we looked at this number of cases in this particular piece of research. We've done thousands since. We had this number of lawyers. We also had peer review of model client cases. I don't know whether you can read what it says here on the cartoon. Can you see the cartoon? Okay, so this guy's standing at the bar and he says, last year, it was all I could do to get the family on holiday. But now, look at them. They're all sitting down at the table. They all have their phones out, and they're all reviewing everything that's happened to them in the holiday. And that's what we seem to do all of the time. I don't do anything without Google asking me to review it. So we all are involved in review, and we are all being reviewed. And what we noticed in terms of peer review were these things, that the instrument, in other words, the criteria that we use, and we're talking now about the specific criteria in relation to the work of lawyers, not all of the other items that were mentioned. The reviewers themselves and how they related to each other. We decided that you need to look at a whole lawyer's work. You need to sample it. You can't look at one case. And we decided also, where necessary, we should double mark. So what did peer review do? Well, it was like, pretty much, it was like looking at an X-ray. It didn't give you all the information, but if you were a good doctor, you would understand what an X-ray was telling you. We found that to an extent, lawyers had buried their heads a little in the ground. Excuse me for having my back to you over here. It's difficult to see what's going on, but I'll turn in this way now. So we found that there was a major difference between the lawyers and the not-for-profit organizations who were working on things. And we found all these differences that we could tell from our peer review system about different cases, how different peer reviews worked, how cases in particular areas worked. And we found this amazing result at this particular time, that the not-for-profit system was actually working better for early advice than lawyers. And that caused the government to give money to the not-for-profits. But let's look at these issues in relation to peer review quickly. Selection, training, the criteria that you use, the sample in terms of how you work out what numbers of cases to look at, and monitoring of the work of the reviewers, and it needs to be a mixture of random and targeted reviews. We had these model clients. So what are model clients? We found that what clients who were surveyed could tell us was limited. So we educated a group of clients to be able to note what was happening to them through the system, but only in the early parts of the system. Obviously, it was wrong to do anything further. And the model clients gave a little bit more information. These are the sort of things they said. They could tell us about access difficulties, about appointments and initial contact. But when the peer reviewers looked at what the model clients had taken in, they found these problems with the advice that had been given: incomplete, inaccurate, woolly. We could see from this what was happening when clients received information and advice, and we devised our system based on that. Here is an example of what the model client said, and look at the bottom about what the peer reviewers said. This is the same case. Model client said, the advisor showed an impressive level of concern and understanding, was very helpful, reassuring and personal. The peer reviewer said, although very clearly empathetic, this advisor does not really know enough about the law to be using legal aid money. So this is the difference between even a client who is educated to find out what's happening and what a lawyer can tell about it. So we found that clients gave, thank you, some information that model clients gave more, but the only real judgment was peer review. I'm told that because of waiting in the beginning, my time is up, and so I'm just going to stop at this point. Outcome measures are important, but you can't look at numbers of the same cases in relation to a particular lawyer or even a particular firm. However, in relation to one individual case, you can look at the outcome, and that's what peer reviewers do. Thank you for listening.
You actually got a little bit more than the others to make up for the electronic failure. So thank you very much. So we've heard about the bigger picture, about comparison and similarities in how to approach quality legal aid, about the funding, and the next three speakers, actually even the next four speakers, will talk more about specific situations in specific countries, or like our next distinguished speaker, Ms. Natalie Rea, the president of the Court Access Project, founder and senior advisor of the International Legal Foundation. She will talk about changing the practice and lessons in developing a culture of quality defense in post-conflict and transitional countries. So we will hear now about some very specific experiences. Thank you.
Hi, good afternoon. I want to thank everybody here for coming and for inviting me, and thank you. I'm very honored to be with this great panel. I'm going to come from a step one behind, which is, how do you get to basic quality? Many of you are dealing with a legal aid system that's beginning, where the legal aid lawyer is given a bigger role through legislation, through your constitutions, and etc. How do you get these lawyers to understand what their new role is? So the first thing I think for quality is, what does the legal aid lawyers, what does it mean to be a legal aid lawyer? To me, it's a commitment to quality representation for the poor. The people who do legal aid must have a commitment to that, and you're halfway there. The new legislations that come out are not self-implementing. Saying that someone has now legal aid, you have the right to counsel at arrest. Fine. A lot of people don't understand what that means. You can start in jurisdictions where this is not the culture. It's often a question of starting with changing the culture of defense from the get-go. So I have been in many situations where, yes, the lawyer knows now from the statute that they have a right to be at the precinct. They're scared of the precinct. The police officer is not used to having a lawyer at the precinct. There's no room for the lawyer to talk to his client at the precinct. So the idea of saying you have a right to be, the lawyer has a role at the precinct, he or she must understand what that role is. And I'm going to focus on early representation, because we all know that the big difference between quality and no quality representation is early representation. So first thing, what does a lawyer do at the precinct? They don't know. How do you train a lawyer to know what to do at the precinct? I happen to think it's difficult. You can't send somebody on their own. I am of the ILF school myself. I am a big believer in mentoring lawyers, because if a police officer says, no, you, Mr. Local Lawyer, you don't have a right to be here, a mentor can say, yes, let me explain to you why I have the right to be here. The law has changed. Let's read it together. Okay, so because the biggest problem, the biggest obstacle to changing from a kind of passive representation to proactive is to read the statute and educate everybody about what we need to do from now on. So This is what we have to do. It happened to me in Afghanistan, before in 2002, and I showed the statute to the guy at the detention center, and he said, nobody's ever shown me the statute. So we can start there, and it's very, very important. It's important for the relationship to the client. With our new legal aid schemes, our relationship with our clients is very important. This is where the client, as the speaker said, is scared. We have to learn to talk to our clients. We have to teach lawyers to talk to their clients, to care about their clients, to understand that they are scared. But it's also a moment, and the only moment, and the most important moment, to get information from your client. This is the time when you say, where were you? This is the time to identify and locate an alibi witness. This is not just the time, hi, I'm a lawyer, I'm going to see you in court whenever they produce you there. This is a very, very important time. And it's very important that everybody know, in the police station, the detention center, that you have a lawyer. And your lawyer is here, and so that they're not going to beat up a confession out of you. They're not going to torture you. And this is something lawyers must learn, and they must learn day by day, case by case. You have 1 step forwards, 3 steps back. One day you go to the precinct under the new statute, the cop lets you in, the next day he doesn't, and the next week he doesn't, and you have to keep going back, and you have to ask again, and you have to say, maybe I could talk to your supervisor. It's not something that you learn so easily. And you have to, the idea of having a mentor with you from a jurisdiction where lawyers are used to doing that kind of work is incredibly helpful. And I really suggest to all of you who are starting these new kind of proactive defense services to reach out to organizations like the ILAC that can help you in training your lawyers to these new practices. The second step in this, the second point I want to make is that the most important, in my view, at this point, the most important people in ensuring early access is the judiciary. It's very difficult to make the system work. It's difficult to ensure this early access. There are too many players. There are police officers. There are detention centers. There's inadequate legal aid services. But there's always a legislation in every country that says within 24 hours, 48 hours, whatever it may be, you must appear before a judge. And that doesn't happen. And we must make that happen, because it's only then that we can make sure that a judge knows that Mr. So-and-so or Mrs. So-and-so is detained, and she or he has a right to a lawyer. And it's the judge's job to do that. And therefore, we have to ensure that this time frame that is so critical, that everybody overlooks, is really implemented. And so now for my little sales pitch, I'm saying that today, in 2018, it is no longer acceptable to have a delay in this time frame. Today, with technology, that delay we can end that. And I'm very happy to be part of a project that's here for the first time after several private rollouts in New York. And technology with the app of the Court Access Project is simple, user-friendly, inexpensive, and it will notify courts of every arrest. And that's really the first step to ensure this oversight. So those are the 2 points I wanted to make. And I had something I wanted to respond to, but I don't think I forgot. So, oh yes, for all of you who took a pin from our table at the Court Access Project, feel free to come and ask how it works. Thank you very much.
Thank you so much, Natalie, for highlighting the quality of the system. And I'm very happy that our next speaker will pick right up where you left off about the important role of the judiciary in ensuring quality and effectiveness of legal aid services. So please welcome with me our next speaker, the Honorable Justice Sapanda Pradhan-Mala, Justice at the Supreme Court of Nepal. The floor is yours.
Good afternoon. And not easy for the panel because after lunch, we have to make sure everyone is awake. And before I came to the podium, my colleague Natalia asked me if I'm going to speak from the seat or going to the podium. And she also said, judges are used to sitting and speaking from the bench, from the seat, from the chair. But what I'm going to tell you, judges can also stand and speak from the podium when it is necessary. I'm going to share the benchmark Nepal judiciary has created in ensuring legal aid. And generally we say law matters because law creates accountability. But in Nepal, when the intervention started from the Supreme Court in institutionalizing legal aid, it was decided through the administrative order of the full court of the Supreme Court with two lawyers and which we call like Vaithanik lawyer, court-paid lawyer. Now it has been institutionalized in all the courts from district to high court to the Supreme Court, and it is one of the most functional mechanism we have in the country. Of course, I also have to acknowledge there is a legal aid committee, there is a bar or other civil society who are also providing the legal aid. But in Nepal, this mechanism was created in 1958, even before the ICCPR, Civil and Political Right Covenant, came into place. Secondly, I also have to mention the role court played in expansion of the right and bringing right-based framework in recognizing legal aid as a right and legal providing services as a responsibility of the state agency. And in one of the cases which came as a PIL, the court even mentioned that denying legal aid is a denial of right to liberty. And it also said it has to be even extended to the non-citizen. And the court said, when you provide the legal aid services, you have to make sure it's a dignified and confidential. So court can play a different role, and PIL can be even a strategic tool to empower and expand the right where there is no clear right within the legal framework, within the constitutional framework. Third, then I would also like to mention, as a result of the court initiative, we have 97 lawyers working in a different court, and they are not only providing pleading services, but they are also writing the cases, helping in writing, visiting the prison. And another initiative we have made is we are also providing template in our website, which can be accessed by anyone. And we also have provided support staff even to fill in the template. Again, I also have to recognize the role BAR has been playing. Nepal Bar even recognized at early stage the role, importance of pro bono, and also started legal aid in an initial stage, even before the law came into place. Third thing, what I also want to mention here, yes, today we are talking about quality, quantitative data, but in Nepal at the initial stage, we even had to confront for the number, increasing the number of legal aid service providers because people had no interest. And only learner or freshly graduated would come without skill, without effectiveness. And then we found what could be the reason, and we found it's associated with the compensation and benefits as well. So now we have these 97 lawyers who is working are at officer level. Their compensation and benefits have improved as a result. There is also improvement of the quality of the services. But then I think we also have been facing a lot of challenges. I also want to share the challenges so that we can get some experiences from you. The challenge is high demand, low services. And we also confronting challenge on making appointment transparent. And then also realized court has been able to engage with the legal aid only when the cases are coming to the court. We have not been able to provide early services. Only now one pilot project has been initiated, and where service is initiated from the early stage. And also what we have realized, pro bono can make difference, and we have prepared a guideline on pro bono, which we submitted to the Bar Association for their consideration, and we are happy to learn that they have recently even adopted, because for the quality service you need lawyers who are senior, who have more capacity. But then other challenge we are facing is, of course, an inadequate budget, because it requires a lot of budget. But then we are hoping the Ministry of Law is making a new policy which will take into consideration some of the challenges. And we do have a reporting process. We do have a monitoring through inspection and annual report. But what we have realized is that we are still looking into the number. We have not been able to look at the quantity. Yes, justice is collectively demanded, but it is individually experienced. And we need to bring the experiences of the person who has been a service seeker, who has been receiving the services. We have yet to get their experiences. We also have been thinking that judges who can examine the effectiveness and quality services, how to bring their experiences as well as experiences of service seeker, not only monitoring and examining the effectiveness with the third party. We hope with new policy, which will be adopted by the Ministry of Law, will take into consideration into all those issues, as well as another, and the final comment is the parallel system which is going on, parallel services from private sector, from the government legal aid committee and the court. So how to coordinate, how to make it more collaborative, and how to make sure that the functional system can be strengthened. And that is where we are at the moment in the country, and thank you for this opportunity.
Thank you very much, dear Judge. And now we are moving to yet another group of clients, the victims, which in many countries do not yet receive legal aid services or do not receive the quality services that they need in order to have their rights heard and applied in the justice system. And we all know that it is a bit different to represent a victim than an accused, a suspect of a crime. So our next speaker will talk about national measures that have been done to strengthen the position of these people. And I welcome Ms. Minh Nguyen, the General Director of the National Legal Aid Agency of Vietnam, who will talk about legal regulations on quality of legal aid services in Vietnam, practice of effective cases of victims of gender-based violence. Minh, you have the floor.
Good afternoon, everybody. Thank you so much for Parliament of George and UNDP to invite me here for the very interesting and meaningful conference. Today I'm talk about how to improve legal aid services in Vietnam and the case of the victims of gender-based violence in Vietnam. In Vietnam, you may know that we have a new law, just a National Assembly passed in June 1917 and take effect from 1st January 2018. That is to say that our new legal aid law have effective nearly 1 year. So according to our new law, so one of the most important targets of legal aid activities is beneficiary-centered, which means that legal aid beneficiaries shall be provided with legal assistance once they are in demand, so as to the best protect the legitimate rights and interests of legal aid beneficiaries. In order to achieve this goal, the quality of legal aid needs to be enhanced in order to guarantee that the state legal aid services shall be equivalent to the paid legal aid services in the market. Therefore, the spirit of the legal aid quality is appeared in almost all chapters of the new law. Under that orientation, the law has specific requirements for the legal aid providers, legal aid providing organizations, legal aid providing process, and quality evaluation of legal aid services. With respect to the new law, so the law adds more requirements for legal aid providers to ensure the professionalism in legal aid services. According to our new law, we have 4 groups of people who can provide legal aid services. First, legal aid officials. Second, practicing lawyers. Third, legal consultants. And fourth, legal aid collaborators. In Vietnam, legal aid officials are not called lawyers, but they have the same qualification and skills, ethics as requirements for practicing lawyers. It is very new provision for in legal aid law in Vietnam, because before that law 2006, there was no requirement equivalent from the legal aid officials and practicing lawyers. But now the legal aid officials they have equivalent qualification as lawyers and the same ethics for practicing lawyers. But they are not called practicing lawyers, and they are not called lawyers. They are called legal aid officials. They are state servants, and they are paid by the state, and they appointed by the People Committee of provinces in Vietnam. But you know, practicing lawyers in Vietnam, not all practicing lawyers who want to do legal aid, they can do, but they have to be selected by the provincial legal aid centers. So we have 63 provinces, and we also have 63 legal aid centers, which can select and sign the contract with practicing lawyers to do legal aid. And also we have a legal consultant. Legal consultants should be also contacted by the legal aid centers. That is to say that legal aid consultant, they register with the local Department of Justice, and then they have to be selected by the legal aid centers so that we can do legal aid. Legal aid collaborators is non-lawyers shall only be employed in the areas which exceptionally difficult economic conditions. They are retired people. They have a full civil capacity. They have good moral quality, and they are like former legal aid officials, former judges, or investigators, or prosecutors. That is to say that legal aid collaborators, also the people who have legal knowledge, deep legal knowledge when they are in charge. Regarding legal aid providing organizations, besides 63 state legal aid centers, they are also contacting with the Ministry of Justice, contacting with the local Department of Justice. That is to say that local Department of Justice will have some criteria to choose legal aid providing organizations. That is to say that they have to go through a very strict process to be selected to contact with the local Department of Justice. And I would like to say that the new law gives the local Department of Justice very strong power in selecting legal aid providing organizations. It depends on the capacity of the legal aid center. Legal aid center is state organizations, and depends on the capacity of the legal aid center. So the local Department of Justice will decide how many legal aid providing organizations shall be selected. So I can say that the process a little bit strict under the new law and subordinated organizations, subordinated documents. In order to have a good legal aid services, so under the new law and under the new subordinate documents, we have set the process for the assessment of the legal aid services. So assessment has two steps. First is internal assessment within the legal aid providing organizations. That is, we have a process for peer review. So the senior lawyers or senior legal aid officials can examine the quality of the services of the other legal aid providers. And the second step is assessment randomly. That is to say, the local Department of Justice and the Ministry of Justice, is mean our department can assess the legal aid services of the legal aid providers randomly. So every year we don't assess all the cases, but we assess only randomly. And if the case is not meet the requirement, so the lawyers cannot be can be terminated contract with the legal aid centers, and legal aid providing organization can be terminated the contract with the local Department of Justice. So because of the time constraint, I just would like to inform the conference about how we improve the services for the victims of gender-based violence. Currently, legal aid providers in Vietnam do not have specific certificate or in-depth education and on illegal aid implementation for specific beneficiary in general, and for victims of domestic violence in particular. However, with training workshops and training courses sponsored by different donors, for example, UNODC also sponsor some training courses to legal aid providers in Vietnam. And we can say that the quality for legal aid services for the victims of gender-based violence in recent years much improved. Why I say that? Because normally, you may know that in Vietnam tradition, so women are usually very scared and hesitate to talk about themselves, to talk about the domestic violence to other people, because there is saying that everything in the family is kept inside family. It's not disclosed to outside. And that's why women, many cases that women hesitate to tell their cases to the legal aid centers or tell the case to the legal aid providers. Being aware of the psychological issue that those victims might encounter, legal aid providers often try their best to create a favorable place and a very cozy atmosphere for legal aid beneficiaries so that they could feel comfortable to share their stories and request for assistance. Under many circumstances, legal aid providers even meet survivors of domestic violence at private room or very confidential place, which is suitable for legal aid beneficiaries to overcome hesitation and have sensitive questions. In the process of providing legal aid, the service providers proved to be professional, knowledgeable, to able to effectively apply their legal expertise in all cases. They frequently encourage victims to trust, share information related to cases, and the state of violence use open-minded questions to help victims feel confidence, avoid offensive and sensitive questions, and judgment on case. there was the case that if the legal aid providers do not have specific skills or professional skills, so even some cases, if the legal aid providers do have skills, they may give not very good questions, and then its impact on the psychology of the victims. And that's why, under the circumstance that the husband has awareness, legal aid providers shall be willing to privately meet and explain to husband, to perpetrators, and explain the problems and offer the advice when necessary. And that's why we use all the method, all the legal efforts and also psychology efforts to help the victims of gender-based violence. And it includes, I would like to say that victims of gender-based violence more and more use the legal aid services over the country of Vietnam nowadays. Thank you so much.
Thank you, Min. Now, without further ado, I will hand over to our last but not least speaker of the session, the Honorable Joanne, a judge and head of Durrës District Court in Albania, who will talk about a pilot of free legal aid in district courts and ensuring quality services to marginalized women and men in Albania. You have the floor.
Thank you very much. It is working, okay. Thank you very much. I'm very happy to be here. And since I'm the only thing between you and the tea break, I try to keep it short. Well, for many of you, I'm sure that you haven't heard about Albania. And just to show you somehow where it is situated, if you have heard, of course, you have heard of Italy and Greece. And these two big countries are two of our neighbors. Of course, we have some other neighbors, but I mentioned just Italy and Greece because I'm sure all of you have heard of. Albania is a small country, and we have a very small population. I mean, compared to Georgia, we are almost the same, around 3.5 million, from which around 1 million people are situated in the capital of Tirana, and then in the other part, not too much people are situated because we have also a high number of migration in all over Europe mostly, but also in other parts of the world. Now Albania has been a communist country for 50 years, and since 1991 we have changed our system, and now we are a democratic country, but of course, as you can imagine, our democracy is somehow fragile and we have many challenges. In 2006, we had a very huge reform, and we called it the justice reform because the main aim of this reform was to take very big steps in the justice sector, by which the most important parts were reforming the justice sector, especially the fight against corruption, and also dealing with some of the institutions that were not effective. And one of these main issues in the reform was the criminal justice reform that was basically reformed. And we introduced in our criminal procedure code two main figures, which one of them was the figure of the victim. Now the victim is participating actively in the trial. And then the other one was ensuring that juvenile or children in conflict in the law had appropriate care taking off. Now we had the legal aid since 2008. We had a law providing for the legal aid, but the law was not effective at all, unfortunately. And since we had this reform in 2016, in 2017, what we did was that we also amended our law on legal aid. And according to the new law, legal aid, of course, we took a model that not everybody is happy with. But the biggest problem with the law was that it was supposed to start functioning in June 2018, but it didn't. Because the bylaws were not approved by the Ministry of Justice. And of course, basically, mostly of funding issues, they were not effective. So what did we do as courts? we had in our criminal procedure code some that I'm sure that most of the countries have, some of the situations where defense is obligatory. And in those cases, we as courts provided with lawyers, appointed lawyers. But then we had other situations in which the defendants so we didn't have, according to the law, obligatory defense, but the defendants, we could see that were not in the appropriate situation to defend themselves or to provide themselves for legal advice. So as courts, we couldn't appoint an ex officio lawyer, but on the other hand, we really knew that that specific person, especially children or victims, were in need for legal advice. So we decided, some of us, to take a proactive approach and to try to find and mostly work with NGOs and other organizations that could offer some kind of help in this regard. And we were lucky enough to find UNDP at the time, so we started in September 2017, a kind of a piloting project by which we established, so we decided we were 4 courts in Albania, for 4 first instance courts, that we decided to enable one of our facilities, an office, to some lawyers that would be chosen by the UNDP project to help us by providing legal aid. How did we do it? We, of course, didn't choose the lawyers, but we said our priorities are some of the marginalized groups. So we said, for example, that we would like to have lawyers that are specialized in domestic violence cases, lawyers that are specialized in dealing with children in conflict with the law, because this was our main focus in having lawyers specialized on that, lawyers that knew also how to communicate with Roma and Egyptians minorities, because we have 6 minorities in Albania, and this is the mostly victimized group of people. And we also wanted to have lawyers that could that were also specialized in property cases. Because according to our legal aid law, not only criminal cases are covered by legal aid, but also civil and administrative cases too. But of course, our main focus was in the group dealing with criminal cases, since in the criminal cases, the sensitivity of the defense is still very important in Albania. And of course, so the donors themselves chose the lawyers with the specific qualifications. We offered the facilities, and in a year, so this September 2018, we did an evaluation. In the meanwhile, it was very important to work with the judges and to have this proactive, let's say, behavior of the judges in referring cases. So whenever a judge could see a defendant, a victim, or somebody participating in the procedure that could be in a position of needing legal aid, we as judges were active in informing the public that, look, we provide, not as a court, but the state, but we provide the service. You could find that in the first floor. You could go ahead and have some contacts with the people there. Because what we found out was that people didn't have any information on the obligation of the state to provide them with legal aid, and they could say that only that I cannot afford a lawyer. So this is what we usually hear. And the numbers that we had, I mean, all over Albania, in these 4 offices that were established, the people that were dealt by was, the number is 1,500 cases that were closed within a period of time. Of course, the number, I'm sure that the number of people that have gone and that have asked for legal aid has been much higher, but of course, due to human resources and to other factors, and since these offices were pilots, only this amount of people was possible to be provided help with. And by this number, 53% were females and 47% males. So you could see that the number is not that, it doesn't differ that much. So it also shows that not only women, but also men are in a situation that needs help. I'm not saying that this model that we chose is the best model and could work everywhere, but I'm just saying that, of course, it depends on your own situation of the country and on the legal basis, of course, the legislation. But it was a good model, first of all, seeing the proactive behavior of the courts themselves, so having this implication and not only the passive role that the courts have usually. And secondly, we took our data, so what we provided from this project, and we showed them to the Ministry of Justice, so to the executive, and we said, look, without your help, we were able to reach these results. So you should know that if you properly are going to do that, you should take in consideration, so you should consider our result and you should see how to do it better. So for example, one of the issues that we were discussing was whether it is appropriate to have in the courts such offices also offering primary legal advice, or it is appropriate to have only offices that offer secondary legal advice. And of course, I'm not going through that debate here, but I'm just mentioning that we got good examples, and also we have situations to talk about and to think about. Thank you very much.
Thank you very much. And saying that we just started 1 hour ago with this session, we learned a lot about the importance of implementing laws and giving them life by delivering quality services. We learned about the importance of performance standards, of providers having the right skills and training to service marginalized groups and protect important human rights. And also that it's very important to ensure that other criminal justice system actors, not the lawyers, but the judges or the prosecutors, help ensure that quality services can be provided so that actually there are lawyers. I know that we are on time for our session, but we are still over time overall, so maybe we have 2 questions and then we move on, or we just go to the tea break. Okay. Yes. Okay, Kaka, please.
Thank you. My name is Kaha, and I'm from UNDP, Georgia. I have a question about the quality and professional ethics. Sometimes I hear from the lawyers in Georgia that professional ethics, they cover the quality. And if you do the quality assessment in addition to the discipline of the bar, from the point of view of professional ethics, that means that means doing the same job, you know, and it's the responsibility of Bar Association to monitor professional ethics, and that's the quality. And my question to the speakers is, what is the relationship between professional misconduct and the quality assessment? Is the professional misconduct, is the monitoring over professional misconduct the same as the quality assessment, and is it enough? That's my question, because this question is often coming from the bar and from the lawyers. Thank you.
Okay, we'll have maybe one more question and then we answer, please.
Good evening. I'm Amun Attili from UNDP Palestine. So my question is about pro bono and the quality assurance. If it is like, will be applied, the quality assurance the same like if when it is provided by a legal aid commission or institute, or it will be, because it is voluntary, you know, pro bono. From your experience, is it like the same standards we need to apply when it's pro bono, or it will be softer than that?
Thank you, and maybe one, yes, please.
Bonjour, je suis Anouar de la Tunisie, je suis juge du tribunal administratif. J'aimerais bien tout d'abord Pour l'accès à la justice criminelle, oui, c'est vrai, c'est important de la justice criminelle, mais il y a aussi la justice administrative où on n'a pas parlé. Deuxièmement, j'ai une question concernant est-ce qu'il y a un suivi de l'aide légale? Suivi de l'aide légale, c'est-à-dire est-ce que l'efficacité ou est-ce qu'il y a une gouvernance en matière de évaluation de l'aide légale après les affaires tentées devant la justice. Troisièmement, je vais parler de l'aide légale. On parle toujours de vulnérabilité. En Tunisie, on a une expérience différente. On parle de l'intérêt du sujet à protéger. Par exemple, Madame a parlé de la violence basée sur le genre. En Tunisie, on vient d'avoir une loi, mais qui prévoit l'aide légale à toute femme, peu importe son état économique. Donc, c'est une aide légale à toute femme objet de violence, victime de violences politiques. Et là aussi, c'est une bonne pratique, que ce soit pour la loi contre la violence faite aux femmes et également le traite des êtres humains. Donc, l'approche peut être autre que la vulnérabilité, mais l'intérêt du sujet. Et dernièrement, j'aimerais bien parler de... on a vu des expériences différentes aujourd'hui dans différents pays, mais le plus important, on n'a pas un modèle à suivre, mais tout dépend de l'environnement de l'aide légale, c'est-à-dire l'état de la démocratie, l'état de droit et le respect des droits humains. Et donc, dans un pays où on a les bonnes pratiques en matière d'accès à l'aide légale, parfois le pays peut lui-même violer tous les droits humains. Et merci.
Okay, can I ask one point for clarification? So you are asking basically two parts: if the victims and the women are also protected by the legal aid laws, and the performance standards, if they just apply to legal aid lawyers or to all the lawyers that provide services. Did I understand this correctly?
The criteria for giving a legal aid. It can be not only for poor person, it can be also for some subject that the country consider as the strategic for protection for example, human rights or for women against violence.
Okay, thank you.
Well, of course it depends. There are different models. In my country, we have chosen the model in which we have not only specified, as you mentioned, the legal aid only for example, for criminal offenses, but also for categories. For example, children in conflict with the law, domestic violence victims, and victims of other gender-based violence are provided with legal aid, so irrespective to any other situation. So it is just enough to be part of one of these categories in order for you to be provided with legal aid. But of course you have different other models in different states, also in Europe, that they do not specifically link that to a specific category. Of course the EU directive, for example, gives some insight on that, but it remains with the legislators themselves.
And if I may add to that, if you look at the UN principles and guidelines that, as you know, are non-binding, but they are based on good practice all over the world, and also the aspiration where countries and experts from countries thought this is the gold standard. For example, the victims of gender-based violence are mentioned in one of the provisions where there are several groups, but of course, as the distinguished speaker said, it depends on what the government prioritizes and also what it can pay for. That is often also a consideration. May I give the question from UNDP Palestine on the standards for services provided by different providers, maybe to Jago? Would you like to answer? Or the judge, of course.
Thank you very much. I mean, there can be no distinction. You providing services to poor people, the clients are the same, whether you pro bono or you paid or you legal aid, the standard is the same.
Okay, yes, thank you. Brief and... Would you like to add?
I think the question from Giorgio was about ethics and...
No, this was from UNDP Palestine.
I'm so sorry.
But please go ahead and answer the question from Georgia.
May I? Thank you. So, in many countries, it is ethical for lawyers only to work with competence. So, it's not ethical to work in an area if you're not competent. However, it is the case that bars are rarely involved in dealing with issues of competence in relation to their own lawyers. And one has to remember that bar foundations are pretty much trade unions in the same way as they look after their own members, and they also need to think about clients and the needs of clients. It's quite often in legal aid systems that quality is considered within the system. I think you've heard about South Africa today, and you've heard also about the situation in England and Wales. So when competence is considered within the system, in other words, through some form of review, one of the issues that is looked at is the ethical relations that the lawyer has. Quite often there are issues of confidentiality, there are issues in relation to different conflicts of interest that might occur, especially in criminal cases. And those are certainly pointed out in terms of review. And where there is such an issue that is so dangerous that it needs to be reported to the regulator, then that certainly happens.
Judge Mlambo, would you like to add?
Thank you. I think I just wanted to add to what the professor said about that. You know, professional ethics as well as quality. It's a question we hear all the time. But our experience, and in South Africa, we did what we did because we realized that the professional bodies protected their members. When ordinary members of the public complained about not being served properly by legal professionals, they were pushed from pillar to post until they lost interest. So let me illustrate this by one example. We check whether when you had your brief, you cross-examined. A lawyer who says, I didn't find any need to cross-examine, how do you, as a professional body, say he was unethical? Yet you can find that there was a lot of stuff there you could have cross-examined on that could have made the difference between a conviction and an acquittal. That's why we do what we do. Thank you.
Thank you. I think we have to go into the break now. I'm very sorry that we didn't have more time for this session. If you would like to, let's say, ask more technical questions on specific tools, how to measure quality and other topics, I would refer you to the parallel session 11A that we have tomorrow, where some of the speakers will be again, and also where maybe some of the speakers that are on the panel here today may be in the audience if I can ask them, so we can maybe then continue our Q&A then. I assume, sorry? Yes, okay. Jennifer just tells me, please be back at 4 so we can catch up with the schedule. Thank you very much for your attention. Bye.